You are sitting in a detention facility and you ask for a prayer rug or a special meal that matches your faith. And somehow that simple request turns into a paperwork battle worthy of a soap opera. It sounds small until you realize religious freedom in detention is protected by real federal law, not just good vibes. The main tool here is the Religious Land Use and Institutionalized Persons Act, which most people just call by its initials because saying the whole thing 5 times a day is exhausting. This law says government facilities cannot substantially burden your religious practice unless they have a really good reason, like actual safety concerns, not just inconvenience. Think of it like this. If the guards can accommodate someone's peanut allergy without blinking, they can figure out a halal or kosher meal plan too. The excuse of "it is too hard" does not hold up well in court once a judge starts asking pointed questions. So what happens when officials just say no? The first step is almost always an internal grievance, which is basically detention's version of a customer complaint form, except the stakes are your dignity and constitutional rights. You file it, you keep a copy, and you document everything like you are building a scrapbook for a lawsuit. Dates, names, and exact words matter, because vague complaints get vague responses. If the internal process goes nowhere, that is when an immigration lawyer becomes less of a luxury and more of a lifeline. They know how to escalate through the Department of Homeland Security's Office for Civil Rights and Civil Liberties, which sounds fancy but is really just the government's internal watchdog. Lawyers can also file what is called a habeas corpus petition if the denial is severe enough, which is a fancy Latin phrase basically meaning prove you have the right to hold this person under these conditions. Courts take that seriously, especially when religious liberty is involved. Here is a twist people do not expect. Sometimes the fastest fix is not a lawsuit at all, but a well-written letter referencing specific legal precedent. Facilities often back down quickly once they realize a lawyer is not bluffing about knowing the rules. Cultural needs can be trickier than religious ones because the law is a little less crisp, but discrimination protections still apply. If a facility treats one group's cultural practice as normal and another's as disruptive, that inconsistency becomes powerful evidence. You might wonder why any of this even happens if the law is so clear. Bureaucracies move slow, staff get undertrained, and sometimes decisions get made by whoever is having the worst day at the front desk. That does not make it acceptable, it just makes it common. And common problems need consistent pressure to fix. This is where persistence beats perfection, since one polite but firm follow-up letter after another slowly builds a paper trail nobody can ignore. A little historical context helps too, since these protections did not appear out of nowhere. They grew from decades of court cases where people's basic dignity was tested and, thankfully, mostly upheld. The real lesson here is not just legal, it is human. Treat preparation like your best friend in an unfair system. Know your rights before you need them, write everything down, and never assume silence means you have no options. So if you or someone you know is dealing with detention conditions that ignore religious or cultural needs, remember there are real remedies and real lawyers who specialize in exactly this. Do you want to learn more about how we help with cases like this? Check out our links in the description below.